So here I am in hot, humid Florida. This is kind of what my life is like. It's constantly under heat and suffocating humidity, but it's also a wonderful place to be with the birds singing right now and my children inside having fun with their friends. Um, I also have a fly buzzing around me, very poetic. Okay, so I am here today because I am going to read a letter, that I've written to the 18th Circuit Judicial Court of Florida. So, without further ado, here it goes. Dear Seminole County 18th Circuit Court, as the judge in case 2020 DR 001856, I am coming to you with a concern that I have about violations of my rights within various realms of federal, state, local, and civil laws. The necessity of writing this letter stems from the profound injustices that I and two minor children in my care have endured, including the deprivation of equitable distribution, the denial of my right to adequate legal representation, and the uncertainty surrounding charges against me. These circumstances have left me in a vulnerable position with limited recourse to defend my rights and interests. As a result, I am compelled to advocate for myself and seek redress through alternative means, such as this letter, in order to assert my innocence and protect my fundamental rights. This correspondence is a manifestation of my inherent right to self-defense and a testament to the enduring pursuit of justice despite the formidable obstacles that I have faced in this case. I am writing to bring your attention to the violations of my constitutional rights that have occurred in the proceedings of my case. I believe that my rights have been egregiously violated, resulting in a miscarriage of justice. Acts of terror and intimidation have been used toward this end, including having an arresting officer in the court standing behind me when coerced to sign paperwork for the forced sale of the home that was awarded to me in the final judgment of our divorce case, which also effectively denied my Florida constitutional right to Article 10 in regard to homestead. Attorney Wallace, John Wallace, and his client, Dr. Anthony Grajeda, furthermore hid the actions from me wherein legal action was required to complete the sale of my home, which is exactly what I testified to in November of 2023 as being the thing that was standing in the way of me purchasing my home as the court had ordered. After I was held liable for being unable to purchase my home, Attorney John Wallace and his client, Dr. Grajeda, hid from me the legal actions that were required to complete the purchase and the sale of my home in May of 2024, as it was then forced by the court. The same legal actions that I and my witnesses testified were necessary for my purchase of the home, and the same legal actions denied by Dr. Grajeda and his counsel as being necessary. After the fact, Dr. Grajeda, Attorney Wallace, and Attorney Paul Urich, along with Kwaku Mitchell, realtor appointed by the court, failed to inform the court that recent actions show the testimonies of Dr. Grajeda, Attorney Wallace, and Attorney Urich provided since November of 2023 and before then too, in this regard to be perjury. It was impossible for me to purchase my home, and these individuals conspired together, contrary to the final judgment, to effectively deny my right to purchase my home. Their actions have deprived me of finances, have refused my right to act in and on my children's behalves to protect ourselves, and these actions placed a cancer patient and two minor children in uninhabitable living conditions due to failure to sign insurance checks for Hurricane Ian damage. The damage occurred in September of 2022, and the checks were denied signatures until April of 2024. I am an abuse victim and a mother attempting to shield two children from abuse while facing 5 powerful men in court. For my attempts to protect us from further abuse, I have been repeatedly admonished by the court, which has denied the truth of this situation from being allowed on court record. This denial is based on the social investigation. Dr. Grajeda, Attorney Wallace, Terry Mattingly, and Kristen Guerido conspired to influence the court to believe that I suffer from borderline and narcissistic personality disorders, which is false. They coerced the court to believe that I was co-abusive, which is also false. The court ruled heavily based on this biased social investigation. I requested that this investigation be overturned due to the gross injustices it continues to enact upon my and my children's lives. My request was denied. Other rulings, such as that in regard to sexual assault, were ruled upon while disallowing Attorney Carson from my providing testimony at the trial. Attorney Carson was told to stop presenting evidence from Dr. Grajeda's journals and was coerced into not calling Roberta Marowitz and Laura Riddle to correct the record based on the judge stating that he already knew how he was going to rule in this case, in this regard. He was ready to rule without having the evidence even presented in court. Attorney Carson stated that prior to trial, while I was going through the worst of stage 3 colorectal cancer, Honorable Judge Brzezinski stated that there were no good people in this case as a reason for Ms. Carson to ignore the fact that Attorney Wallace had altered evidence to try to file sanctions against her. It is not true that there are no good people in this case. I am a good person. I am an honest person. I am not an abusive person. These are the very things that Dr. Grajeda hated most about me. And our therapist's recognition of these facts, that I was not the person that he says I am, was part of the reason that Dr. Grajeda kept changing mental health counselors. Dr. Grajeda has been using a false diagnosis to imprison me and our children in his abuse since at least 2014, and I have evidence that shows this to be fact. And I have presented it to the court when asking for the social investigation to be overturned. Under the Florida statute, specifically Chapter 39, the abuse and exploitation of vulnerable individuals, including children and victims of domestic violence, are strictly prohibited. Allowing Dr. Grajeda to continue his actions violates these statutes, undermining the legal protections afforded to victims. Additionally, under the Americans with Disabilities Act and the Rehabilitation Act, individuals with disabilities, including those affected by mental health diagnoses, which in my case is PTSD, panic disorder, and anxiety as a result of 20 years of abuse, individuals with disabilities are entitled to protection from discrimination and they are entitled to protection from abuse. I have been denied both. I now have police body cam footage of Dr. Grajeda making false accusations about my mental health and about alcoholism as a means of depriving me and our children of freedom from abuse and the right to speak out against the injustices occurring under the watch of the 18th Circuit Court in case 2020 DR 001856. The truth is that I wish to stop drinking with him for over 10 years, as drinking always led to sexual, psychological, and physical abuse, and depriving me of peace and dignity and humanity, human rights. For quitting, Dr. Grajeda called me a prude and told me it was boring to hang out with me if we weren't drinking. There was nothing to talk about otherwise. Dr. Grajeda's incessant lies continue to cost me and our children freedom from abuse and harm, which he carries out to protect his reputation. I am also not an abuser, did not manipulate therapy, do not suffer from borderline or narcissistic personality disorders. Yet, Ms. Carson, Attorney Carson, stated that the court wouldn't hear me on these facts as I had no proof that Dr. Grajeda was making these accusations. I have had to wait while enduring 4 more years of abuse to gain that proof, which I now have in my possession in the form of police body cam footage. Dr. Grajeda's actions not only violate Florida's domestic violence statutes, but also infringe upon my First Amendment rights to freedom of speech, as he attempts to silence me from speaking about the abuse. His behavior constitutes a violation of my 14th Amendment rights to due process and equal protection under the law, as his lies and manipulations aim to unjustly deprive me of liberty and property. Additionally, his false statements and actions are actionable under defamation laws, which protect individuals from reputational harm caused by false statements. Moreover, allowing a parent to deny the reality of their children and attempt to force the other parent to do the same can have devastating effects on the children's psychological and emotional well being. This form of psychological manipulation, often referred to as gaslighting, can lead to severe issues of anxiety, depression, and a distorted sense of reality. It undermines a child's ability to trust their own perceptions and experiences, creating long-term mental health challenges. Furthermore, it can damage the relationship between the child and the parent who is forced to deny the child's reality, leading to feelings of betrayal and abandonment. It is crucial for the court to recognize and intervene in such harmful dynamics to protect the best interests of the children involved. Dr. Grajeda's own journals, spanning 4 years, reveal his intent to present a false persona to the public to garner sympathy while concealing his true abusive nature. Allowing him to continue unchecked will perpetuate these legal violations, denying me and my children the justice and protection we are entitled to under law. Therefore, it is imperative that immediate action be taken to address and rectify these egregious violations. Next, I must address the violation of my Sixth Amendment right to legal representation. The Sixth Amendment guarantees the right to counsel in criminal prosecutions and extends to civil cases as well, particularly in cases where fundamental rights are at stake, such as divorce proceedings. The denial of effective legal representation for a significant period during the proceedings has significantly impeded my ability to defend my rights and interests. In September of 2022, my attorney, Shana Carson, was permitted to withdraw as my counsel. However, it wasn't until April 18th of 2023 that attorney Stephen Chambers was granted rights to represent me. This lengthy period without representation left me vulnerable and unable to effectively defend my rights. During this time, I was subjected to numerous injustices, including the denial of my ADA accommodations, the denial of assets awarded to me in the final judgment rendered on June 2nd, 2022, and the denial of my right to child support and co-expenses, as well as other rights outlined in the judgment. I assert that my rights under the Americans with Disabilities Act have been violated. The ADA prohibits discrimination against individuals with disabilities in all areas of public life, including employment, education, transportation, and access to public services. In the context of legal proceedings, this includes ensuring reasonable accommodations are provided to individuals with disabilities to ensure equal access to justice. The denial of my ADA accommodations further marginalized me and hindered my ability to participate fully in the legal process. Despite my attempts to communicate the urgency of my situation, including notifying the judicial assistant of my representation's illness, my pleas for assistance went unanswered. The lack of responsiveness further exacerbated the injustices I faced. Opposing counsel, Attorney John Wallace, furthermore, stated illogically and incredulously that I had two attorneys when in fact I had none. Attorney Wallace would know this to be patently false. He is an expert in laws surrounding representation. He furthermore maligned me repeatedly to my counsel based on false pretenses and put words in their mouths and emails to try to create a written portrait of my counsel as confirming his and Mr. Grajeda's repeated statements that I am a liar who blames everyone else for problems that are my own, which is another lie. Both Attorney Wallace and Dr. Grajeda have repeatedly stalked and harassed me to third parties like my private mortgager, Judy Azumi, realtor Kwaku Mitchell, and my new landlord. Furthermore, I must bring to your attention the actions of Attorney John Wallace, who was permitted to sanction and threaten the bar licenses of my attorneys, including Ms. Carson, Mr. Chambers, and Mr. Randesh Maharaj, for simply telling the truth. It is evident that Mr. Wallace's actions were not only unjust, but also designed to intimidate and silence those who sought to advocate on my behalf. Moreover, I am deeply concerned about the biased nature of the social investigation report relied upon by Mr. Grajeda and his counsel. The report, which heavily relies upon testimonies from individuals who have never met me, unfairly influenced the proceedings of my case and contributed to the perpetuation of injustice against me and my children. Additionally, I find it deeply troubling that Honorable Judge Brzezinski, whom I appeared for as a pro se representative on the stand, would encourage me to trust Attorney Wallace opposing counsel. This blatant disregard for impartiality further eroded my trust in the fairness of the proceedings. This court's refusal to allow my witnesses to correct the record, despite their firsthand knowledge of the situation, only serves to further highlight the systematic injustices that have plagued this case from the beginning. In this, my 14th Amendment rights to due process and equal protection under law have been violated. The 14th Amendment guarantees that no state shall deprive any person of life, liberty, or property without due process of law, and that all persons are entitled to equal protection of the laws. The denial of assets awarded to me in the final judgment, as well as other rights outlined in the judgment, constitutes a violation of these fundamental constitutional principles. Federal and state policies and statutes outline clear procedures and remedies for addressing violations of these rights. Under federal law, individuals whose constitutional rights have been violated may seek redress through civil rights lawsuits, which may result in damages, injunctive relief, and other remedies. Additionally, federal agencies such as the Department of Justice are empowered to investigate and enforce compliance with civil rights laws. Similarly, Florida state law provides avenues for addressing violations of civil rights. The Florida Civil Rights Act prevents discrimination in employment, housing, and public accommodations based on race, color, religion, sex, pregnancy, national origin, age, handicap, or marital status. Individuals who believe their rights have been violated under state law may file complaints with the Florida Commission on Human Relations or pursue civil action through the courts. In light of these violations of my constitutional rights, I respectfully request that my case be fully reviewed. It is imperative that the injustices that we have faced, as well as the complicity of the court in perpetuating these injustices, be addressed and rectified. Moreover, I believe that these situations bleed into other violations of my and our children's civil and constitutional rights, including the Fourth Amendment right to privacy, with unwarranted intrusions into my privacy happening regularly, the First Amendment right to freedom of speech, with 4 years of successful attempts to silence me and suppress my freedom of speech, particularly in the context of speaking out against abuse and injustice, my Eighth Amendment right against cruel and unusual punishment, as I and my children have been subjected to cruel and unusual punishment, both physical and psychological. The Fifth Amendment right against self-incrimination, as I have been coerced and pressured into self-incriminating statements or actions, such as the most recent attempt to incarcerate me for 159 days for expecting that Dr. Grajeda follow the oral orders of the court as they are given, amongst other examples. And my Ninth Amendment right to due process and equal protection, as I have been denied unenumerated rights not specifically mentioned in the Constitution, which in the context of this case encompass broader principles of due process and equal protection under the law. In addition to the aforementioned concerns, I respectfully request that you consider recusing yourself from this case and grant a venue change to Orange County. Given the history of bias and unfair treatment in this case, and that has been experienced throughout these proceedings, I believe a change of venue is necessary